Federal Drive is presented by GEHA, Government Employees Health Association, proudly providing health and dental benefits to federal employees and their families. Visit GEHA.com.
Hiring someone is only the beginning of the government's relationship with an employee. A newly finalized OPM rule expands the agency's authority to pursue suitability actions for certain misconduct that occurs after hiring, raising new questions about accountability and workforce management. Federal News Network's Eric White spoke with Michael Fallings, managing partner at Tully Rinckey, to find out more about what's changing.
So the rule has been publicized for a few days now, and it involves suitability actions that can be taken against certain federal employees for misconduct occurred after they are hired. Why don't we kind of start from before time? What did suitability mean before this new rule, and then we can kind of get into some of the changes?
Sure. So suitability means whether a federal employee is suitable for the job. So when an employee is going through the application process, certain agencies would conduct a suitability review to ensure that the employee is eligible for employment. Certain things could mean that an employee is not suitable for the position, such as, maybe even a prior criminal history or a prior job history as well, that an agency could cause an employee not to be hired for a position. So that is where it was. Now, employees that maybe faced a suitability determination that they weren't eligible for the position could still appeal those actions to the Merit Systems Protection Board, but that is where it was prior to this rule.
Got it. Okay. And with this rule, let's get into it itself. What does it say, and how will it affect employees when they are deemed either suitable or not suitable? What changed exactly?
Well, this rule allows federal agencies to take suitability actions for post-appointment conduct, which is a major change because when taking a suitability action for post-appointment conduct, the agency does not have to go through the due process procedures. Previously, if there were something to happen after the employee was hired, the employee would at least receive notice and an opportunity to respond, typically even some sort of investigation as well. With a suitability action, the government could just issue a notice saying, we are finding you unsuitable based on conduct that even occurred after your appointment to the job. Now, that could still be appealable and challenged, but the employee doesn't have that due process right that I mentioned.
Got it. Okay, so while also hindering a little bit of your ability to fight the suitability charge, it seems as if the administration also wants to stretch how and what it can define as, or when it uses the term suitability, it wants to be able to use that for more faults, I guess you could say, of an employee. Is that correct?
Yes. It expands really the time frame from where you could be found unsuitable. So you could be working in a position and then be found unsuitable for conduct that occurred after the fact. It does make federal employment less secure, for these employees that are used to having at least some due process with regards to any action against them. In addition, it allows for the government to use additional reasons to take those actions against the employees.
What is the legal standpoint there of, this is going through the comment period right now. This also hinders one's ability to appeal when they are deemed not suitable for a position. What is the possible legal remedy then for them if they're not able to appeal or anything like that? Are there other violations that could be at play here?
Well, if they are prohibited from appealing, the employees could still go to court and still file in court litigation alleging this is a violation of the Administrative Procedures Act, potentially, depending on the type of employee, alleging a prohibited personnel practice. And there's a lot going on with that to see whether the employees could still file that. Now, if there's a discrimination basis behind it, they could still go to the EO office. But if there's a prohibition on actually appealing a suitability action, then what I would recommend is probably trying to take it into federal court for the employee to continue to challenge that.
We're speaking here with Michael Fallings. He is the managing partner with Tully Rinckey. This all comes while the Trump administration has also put out a new stipulation for future or current federal employees to sign non-disclosure agreements. Could not signing that agreement saying, I can't abide by this or I don't think it's necessary, could that also find you deemed as unsuitable?
I believe that's what the administration is going towards. I think for employees that, from my knowledge, those agreements are given to, employees that are applying to the government, but if they're also given to employees that are, within the government, I think that's what they may find is that you're not agreeing to our non-disclosures agreement. You're not agreeing to keep items confidential. And so we're not finding you as suitable for the position because you can't agree to our terms. I would encourage employees to challenge that to the available methods, but I believe that is what this administration is going for.
Yeah, because that brings in so many other aspects, right? I mean, there's whistleblower protection rights and, that pesky First Amendment rights that allows you to say whatever you want to say, right? I mean, you may have grounds there if it comes down to that.
Yes. Regarding the NDA, I think the major concern has been is the First Amendment rights for employees. Federal employees have First Amendment rights, and the language regarding the NDA hasn't been as clear on what it is actually being that's deemed confidential. The whistleblower rights as well. Now, I know the proposed language regarding that says that employees could still blow the whistle, so to speak, but I don't think it's as clear, and it definitely puts fear in employees' minds about, well, could they really? Well, what may happen if I do? Could there be retaliation? So that agreement, that NDA is also concerning. But, as you said, it seems like the government may try to use failure to sign the NDA as a reason to remove an employee.
Where does this stand as far as OPM's overall changes that they want to make to federal hiring oversight and workforce planning? We're seeing different changes from them on staffing plan requirements, enhanced oversight from chief human capital officers. What is the grand plan here that OPM is going for, you think?
Well, it appears to be trying to reduce the federal workforce and to make it easier for federal agencies to remove employees. Federal employees have had rights to protect their employment for a number of years, for decades, and it appears OPM through the administration is trying to take that away. I think there was a recent proposed rule even about shortening performance improvement plan periods, taking away the due process rights and the analysis, the factors that government agencies must use to determine whether to discipline somebody. I think that was issued maybe just today as well. So all of these proposed rules and regulations appear to allow the agencies to remove these employees quickly without due process and without litigation.
Michael Fallings is managing partner with Tully Rinckey. Thank you so much for providing the insight.
No, thank you for having me.
We'll post this interview at federalnewsnetwork.com/Federal Drive. Subscribe to the Federal Drive wherever you get your podcasts.